After spending more than 30 years in prison for a murder he maintains he did not commit, Darrell Jones is at risk of being sent back again. Ahead of a new trial set to start Monday into the 1985 shooting death of Guillermo Rodriguez in Braude, Jones' defense is dealing with some major recent setbacks. His case was first highlighted by the New England Center of Investigative Reporting and WBUR, which uncovered evidence that his conviction may have been the product of racial animus by at least one member of the all-white jury. On top of that, there was the video testimony used to help convict Jones, which the court determined was tampered with by Braude police. It briefly cuts to a 1950s TV show, potentially omitting key exculpatory evidence. Following the reports at the end of 2017, a Superior Court judge vacated Jones' conviction and ordered a new trial shortly after. Since then, the altered video was ruled inadmissible and will not be shown in the upcoming retrial. But last week, a judge decided witness testimony from the first trial will be allowed, despite the defense's motion to exclude it after a new statement from some of the witnesses contradicted their original testimony. Yesterday, Jones' attorneys filed a motion to throw out his case altogether, arguing the new trial will be a virtual replay of the original trial that was fundamentally unfair to the defendant. Darrell Jones, who is now out on bail, is here again. Good to see you, Darrell. And his attorney, Paul Rudof, joins me. Paul, it's good to meet you.
Thank you, Jim.
Did you ever think there would be a retrial in this case, Darrell? Or do you think that was going to be the end of it when they threw out your first conviction?
No, I didn't think it would be the end of it. I actually wanted a new trial. You know, it was something that I looked forward to because
to clear your name.
To clear my name, because just getting out and, you know, and being free, the public never knew. You know, I went away in '85 and no one ever knew I was even there. So I just wanted to.
So how do you feel? You're 4 days away. There's a motion to dismiss the whole thing, but assuming that fails, your trial starts in 4 days and your freedom is at risk all over again. How do you feel 4 days out?
Well, my freedom hasn't come yet. You know, I haven't had the freedom from the moment that I've been out because I've still been under their watch and dealing with what they did to me, and you don't recover from it that quick. So I haven't taken it as freedom, although I've been happy to be around my family and friends. It just hasn't been freedom.
So do you actually look forward to this trial because you hope at the end?
Well, I looked forward to it before I saw what was occurring now, you know, and what was going on. I looked forward to it. Seeing the way that they're doing it, it makes me unhappy.
I want to talk about the way they're doing it, Paul, with you. Just to go down the list. The doctored part of that tape, that's gone. That's not coming back in this trial.
Correct.
Still no physical evidence, am I right?
Not a shred of physical evidence.
And no motive offered for this?
Darrell and this man didn't know each other, didn't communicate with each other, had nothing to do with one another. He was literally sitting in a bar eating a sandwich when this all happened.
Okay, so I think what Darrell is referring to, about not crazy about the way things are going recently, was the testimony of 3 eyewitnesses from the first trial. They testified in front of the court, I guess, pretty recently,
Correct.
saying that they didn't remember, they were forced to say what they said and identify him by the police at the time. What did the judge say about their testimony?
So actually all of these eyewitnesses have consistently testified about the identification procedures that the police used and have consistently testified, even back in 1986, that they did not identify Darrell Jones as the person who they saw commit the shooting. And what the judge did after this hearing was appoint them lawyers to advise them about their right not to testify. And so it's my understanding that probably none of those 3 witnesses will testify, and instead the prosecutor will simply have somebody read their testimony from 1986 to this jury.
So, but to be clear, the judge ruled that I don't know if it's recanting, whatever they said in a recent hearing, yet again about the cops essentially directing them to point to Darrell, or that they had no memory. He said not credible, in one case affirmatively lying, which led him to say that the prosecutors could read this testimony. The thing I don't understand is, first of all, are these witnesses going to show up?
Well, they have showed up. I mean
at the trial.
Well, they won't, because they're going to be asserting their Fifth Amendment privilege, and they won't testify at the trial.
Now, I was a civil lawyer, not a criminal lawyer. Right. I don't think I've ever heard of this. Is this unusual to be relying upon testimony read to a jury 30-plus years after it's offered?
It's not unusual perhaps for one witness's testimony if they're unavailable to be read to a jury. But in this case, almost every witness will not be appearing in front of this jury. 5 of the 6 eyewitnesses to this crime will not appear in front of this jury, and instead the jury will hear their testimony from 1986 without any opportunity for me as Darrell's lawyer to cross-examine him.
So I'll ask the stupid, obvious follow-up question. Obviously, one of the key jobs of a jury is to assess the credibility of a witness. How do they assess the credibility of a witness when it's being just read to them, not even by the witness, but by a third party? How do they do that?
It's a great question, and what's really unfair is that they will hear live testimony from the police officers who will claim that these eyewitnesses identified Darrell as the shooter, and in contrast they'll hear a cold reading of a transcript from 1986. That's the real unfairness.
This
here.
is what you were referring to a couple of minutes ago about the way things are being done this time around. Is that not what you were talking about?
That's exactly what I mean. The idea of me having a new trial was to get the people to come forward and say whatever they wanted to say, whatever they had to say. And they've basically found a way to exclude those witnesses once those witnesses came forward and said, you made me do it. You told me you're going to take my baby. You told me that you were going to put me in Framingham, And then these people come forward. So it's like telling the public, if you ever recant or you ever come forward with the truth, we'll make sure that we'll do something to contradict you.
Why do you think they're prosecuting you again? Do you think they sincerely believe you're a murderer?
No, I think I just quoted myself the other day to someone, and I was saying that if you thought I was a murderer, you let me out in the world, and then you come and offer me a deal, with, in manslaughter at that. And so if I would have took the manslaughter,
that would have been 4 to 8 years. You would have been out long before.
Well, that was last time, and I think on the show it was 6 to 8 originally, and I would have did 4 years from the beginning of this. Now I've done 32, and now they come a couple of times and make these deals and try to get me to take a manslaughter, which means that day I could have just took it and this would have been over. And I'm going, why would I be taking a manslaughter when I didn't do it, period, no matter how low you make it?
Why do you think they're retrying this case? I mean, even if they believe that this man did kill the victim here, he spent 32 years in jail. And obviously he says he didn't, you believe he didn't, etc. So why do this all over again, do you think?
I think that's a great question to ask the Plymouth County District Attorney's Office. They've said they don't think he needs to go back to prison. They offered him time served, which he's not taking because he didn't do this. And on top of that...
When was that offered most recently?
They offered it in court a couple of weeks ago. But Darrell's not going to say he did something he didn't do. And beyond that, no objective person looking at this could actually say they're sure he did this because there's powerful evidence of his innocence.
I just want to be clear about this. I know you've both said it, but for the people at home and for me, the prosecutor in this case is saying, I am willing to make you a free man, free meaning not in jail. I don't mean freed from the guilt. If you take a plea, you don't go back to jail. You don't ever have to worry about going back to jail your whole life. And instead, you are risking going back to jail for the rest of your life because you don't want to admit you did something that you didn't do? Is that a fair statement here?
Well, that's more than a fair statement. I mean, the reality is it was someone I didn't even know, never met, never saw his face like you and I are talking. So if you're in a situation where something is occurring and you know the person or you can figure out you were around it. But like I said, I was inside of the bar. This is happening outside somewhere away from me that I don't even know it's occurring.
When this most recent offer was given to you, did you even pause for a second and say, well, I still am able to say whatever I want to say in the world. I will be physically free at least. Did you pause for a second before saying no?
No, I would never pause. It wasn't just once. It was offered like 3 different things, 3 different times. I was told that the offer was made, and the last time, in the courtroom, she brought it up, actually, the prosecutor, basically pointing out that he's not taking our deals, as though they were angry about it. And, why would I do that?
Are you comfortable with his decision?
Absolutely, 100%. He's innocent. He's maintained his innocence from the day he was arrested, and he's not going to say he did something he didn't do.
Wish you luck on Monday and beyond.
And what about, if I can say, right?
You can say whatever you like.
I think the reason for me doing it, and hoping that the public will pay attention is that they're supposed to prosecute in behalf of the Commonwealth, not because the DA wants to do it themselves. The victim's family has never participated. No one else has called for this. And if I didn't do this, what about the other brothers and sisters and women and, you know, and people that are incarcerated, that are sitting in prison now that are innocent too? And no one recognize them. What about them? What about all of us? And somebody has to be at the forefront of getting this out for everybody. And my hope is to bring out more cases and identify how this system works. Massachusetts, it's been a secret. Plymouth County is the worst, you know, and if you look back at the investigations that was done on that county for years, them using informants, people need to go back and look at the Brockton Enterprise and various places and look at how they were investigated. And they don't want me speaking out. And this is anger, you know, and retaliation. It's malicious prosecution, no matter how you do it.
Glad you're speaking out. Paul, it's good to meet you.
Thank you very much.
Really wish you luck.
Thank you very much.
Thanks so much for talking.
Thank you for having me.
I really appreciate it.